The big scoop on the Parliament joint session which is being called. Crucial bills will be introduced and considered in the special joint session. Sources suggest one nation, one law bill also likely, women reservation bill also to be tabled. But most important of it all is what everyone has their eyes turned on, which is, will the government go ahead? And sources insist that the government right now will go ahead and introduce the One Nation, One Poll bill in the joint session of the Parliament. I want to cut across to get a larger picture and understanding, because this will require a constitutional amendment. I want to quickly bring in the top constitutional expert of the country, PDT Achary, who's joining us live on this big news break. Mr. PDT Achary, sir, appreciate you joining us. Word is coming, sir, source-based though, that seem to suggest that the government is mulling to table a bill which is One Nation, One Poll. What could be in terms of the constitutional amendment, or what would it take to actually go ahead with a bill like that?
See, I feel that there is no constitutional amendment required, actually, if you look at it from the legal point of view, because Constitution says that every assembly has a period of 5 years unless sooner dissolved. Unless sooner dissolved. That means it can be dissolved at any time before the expiry of its term of 5 years. That is already provided for in the Constitution. Now, how will you go about it if you want to introduce one nation, one poll? That is simultaneous elections, which they have been sort of discussing for quite some time. Now the question is, an assembly which has been elected only recently, maybe half a dozen assemblies which have been elected recently.
Like Karnataka, sir. The last election, yes. Go ahead,
then
sir.
They have to go for 5 years. They have to be there in office for 5 years. Of course, the provision is that unless sooner dissolved. Now, there should be, what is the process of dissolution of a house? The government recommends dissolution of the house to the governor, and the governor accepts it and dissolves the house. That is the process. The same thing happens to Parliament also, the Lok Sabha. Now, the question is, if a state is ruled by a party which is other than the ruling party at the center, and if from here the Home Ministry asks a particular state to dissolve their assembly so that we can move together and we can hold simultaneous elections, suppose they don't accept it. They don't accept it. It is up to them. Parliament cannot, the union government can intervene only through the instrumentality of Article 356. But invocation of 356 can be done only when a certain conditions exist. That means there is a breakdown of the constitutional machinery in a particular state. Only then the center can intervene and dissolve the assembly, not otherwise. At other times, resolution can take place only on the advice of the state cabinet. And that becomes a very difficult thing. Suppose they don't accept it, the request from the Senate. Now, what law can be made? Here the constitutional provisions are very clear. And the procedure that is resorted to in dissolving a house is very clear. These are all set laws. This legal position is all very set, and it is well understood. So what kind of constitutional amendment and what kind of bill, ordinary bill, can be brought about to bring about to conduct simultaneous polls in all the states and the Parliament? Now, if a state is dissolved by the President using his power under Article 356, naturally that will be challenged in the Supreme Court. And there are cases where the Supreme Court had struck down the decision and restored the assembly. So that precedent is also there. So it's a very complicated kind of situation. I do not know In fact, it's not very clear to me how the government wants to go about it and what kind of a law can be brought about it to achieve this object.
Sir, you know, two-third majority is needed for a bill to be cleared. Now, if the bill is cleared, then what? Because what you've told us is a very, very complicated procedure up ahead.
Well, a constitution amendment has to be passed by both the houses with actually a majority of the total membership of the house and two-thirds of the members present and voting. These are the two conditions which need to be fulfilled. And if these two conditions are fulfilled by each house, then the bill is through. So once the bill is through, there are certain areas where the amendment touches those areas. Then, of course, it has to be ratified by half the number of the states in the country. Only after that, it can be presented to the president for his assent. So that is the constitutional provision. Article 368 makes it very clear. It lays down the procedure for amending the constitution. That is the thing.
But sir, right, go ahead, sir.
It is not actually very clear at this stage what kind of law the government wants to bring to make it possible for conducting the election simultaneously. In fact, this is not something new. This used to be the case in the 50s. All the elections used to be conducted together, simultaneously, with Parliament and the Assembly. But later in the 60s, towards the end of the 60s, the Parliament had to be dissolved first, before the term expired. And then the whole pattern changed. Then there was the kind of disturbance of political instability in the states, and assemblies had to be dissolved earlier and all that. So the entire pattern had to change. And then the elections were held to the assemblies at different times and to the Lok Sabha at different times, and that kind of thing happened. So it used to be done in the 50s. But at this moment, it is very difficult to bring about that kind of a situation or that kind of a simultaneous hold.
Right, sir, and especially in states which are not government ruled right now, in terms of BJP ruled right now, those states will not agree to dissolve their assemblies, like the state of Himachal Pradesh and Karnataka, which went to elections this year.
And the center can intervene only through 356. But 356 can be imposed only when certain conditions exist. That is, when there is a breakdown of the constitutional machinery in the state. Only then the center can intervene. Otherwise, no. So the assembly can be dissolved only on the advice of the Council of Ministers of the state. That the chief minister and his cabinet has to recommend to the governor that the assembly may be dissolved.
Right, sir. So very complex. But thank you for breaking it down. Appreciate you joining us and giving us your time, PDT Achary. With that.